Everybody to the 16th Symposium on Emerging Intellectual Property Issues. I'm an associate professor. I'm David Taylor. I'm an associate professor of law here at the law school. I'm a co-director along with Keith Robinson for the Tsai Center for Law, Science, and Innovation. So the Tsai Center explores how law and policy affect scientific research and discovery, as well as the development and commercialization of new technologies. It also studies the converse, how scientific discoveries and new technologies affect, for example, the law and ethics. So in both respects, the Tsai Center offers educational programming, facilitates academic research, provides educational opportunities in these areas to students, industry, policymakers, academics, and the public. And this symposium is just one example. So on behalf of Keith Robinson, my co-director, I want to thank you for being here to participate in this symposium, one of our educational programs. And so let me start by making a few administrative announcements. First, I want to let you know that the panels will take place in this room, and we'll have food that's out. There's a sign on the door that says no food or drink. You can bring the food and drinks in. I see some of you already have it. You're like, oh no. No, you can bring it in. It's fine. In fact, there's more breakfast out there. Go get breakfast. Bring it in here. That's perfectly fine. There'll be snacks as well. Bring those in here. I will say, though, the lunch will be in a different room. It'll be in a different building. Karcher Auditorium and Storey Hall, but we'll help you get there. There'll be signs, there'll be students directing you to help you get to that location. The other point is there'll be breaks in between the panels, so feel free to stick around, and if you need to leave and come back, that's great too. All right, second, if you're an attorney and you need CLE credit, there's a sign-in sheet out at the table, and there's a QR code where you can go and actually register your CLE credit. As well, if you want Wi-Fi, in your packet of materials, there's information on how to access the Wi-Fi here at the law school. Also in your packet, there's a lot of information there for you to take a look at. One of the things is that we have a lot of different programs and opportunities that the Tsai Center provides. So we have the Federal Circuit Blog Project is a major project. It's a blog that focuses on the U.S. Court of Appeals for the Federal Circuit, which handles all appeals in the United States in patent cases. And so we have a blog that's devoted to keeping track of the important patent cases as well as other cases at that court. As well, I'll mention more about this at the lunch, but we're going to have what we'll call an innovation lecture on April 2nd. I believe there's a flyer in your packet. Certainly there's some flyers out on the table. We're going to have Josh Malone, who founded Bunch of Balloons or created the technology. He's an inventor, created the technology underlying what's called Bunch of Balloons. It's this, you've probably seen it on television. It's the ability to create water balloons. In like 30 seconds, you create like 25 water balloons. He created that technology, obtained patents on it, and slogged through years of fights in federal court and at the patent office defending his patents. And so anyways, on April 2nd, we're going to have that event. I'll talk more about that at lunch. So let me also take this opportunity to thank Natalie Greco, who's our Director of Programs and Operations. She just walked in. Thank you, Natalie. So she did, yes, thank you. She did so much of the logistics behind what's happening today that I just want to say thank you. As well, we have what we call Tsai Center Scholars, SMU law students who work with the center. And so they put in a lot of hard work behind the scenes and are working the registration table, for example. And so I don't leave anybody out. I'm going to read their names. But I want to thank them: Elizabeth Chung, Tucker Davison, Carter Christek, Morgan Mendocino, Nolan McQueen, Jason Spots, and Thomas Tassin. So thanks to them as well. So now about today. So the focus of the symposium this year is on opportunities and challenges in creative and innovative industries. The idea here is to explore the impact of changes in technologies on innovators and to explore what is working and what's not working in the innovation ecosystem as a result of these changes in technology and their impact on the various intellectual property regimes, which would include patents, copyrights, trademark, and trade secret law. So looking ahead at the panels, I know you've got an agenda for the day, but I want to give you a kind of a flavor of what we're going to be talking about today. So we're going to start with the topic of software and intellectual property. And we're going to ask the question whether software should be free from intellectual property restrictions, including copyright and copyright and patents. And for example, if trade secrecy is a viable alternative to software protection. So later this morning, we'll focus on creative professionals in copyright with a group of law professors who are going to explore how recent developments in technology have impacted the use of copyright. And then our lunch keynote, I encourage you to stick around. We have great panels and a great lunch presentation. Our lunch presentation, our keynote speaker is Don Passman. He's an attorney literally out of Beverly Hills. He represents music artists. He spent a career representing music artists and has represented some of the music industry's greatest stars, including Taylor Swift, Adele, Elton John, Green Day, Pink, Paul Simon, Stevie Wonder. That's just a short list. He's got a longer list. In particular, what he's going to focus on is the role of copyright in supporting and sustaining creativity, as well as challenges of modern technologies to traditional copyright doctrines. So then after lunch, we're going to address intellectual property legislation. So how is the legislature responding to changes in technology? And we're going to have a panel that's going to discuss legislative reform, and they're going to focus on copyright and patent law. Our last panel of the day, stick around. It's going to be a great panel. This is going to be the non-lawyers for the most part. There'll be one lawyer on the panel. But for the most part, it's going to be the users of the intellectual property system, the actual creators and innovators. And we're going to talk to them to find out some of their war stories about how they've used the intellectual property system and how it's worked for them or maybe some problems with it. All right, so now let me again turn to the topic of the first panel. This is about software and intellectual property. Should software be free? We're going to start that panel in just a couple of minutes. Let me just highlight that one of our adjunct professors, Shannon Bates, is going to be moderating. She's right over here. And she's a partner at her own firm of Harper, Bates & Champion. She's also a clinical adjunct professor here at the law school. She works in our patent clinic. So she works with students who actually represent real clients. They're doing real work representing clients at the patent office when they're seeking to obtain patents. So she's going to moderate our panel. She'll end up introducing the speakers. That reminds me, one of the things that's in your packet is are the bios of all of our speakers for the whole day. So it's likely that you'll have truncated introductions today so we can sort of focus on the substance of the topics that we want to discuss. But I'll encourage you to look in the packets to read the more complete bios. And so I'll just highlight this first panel. I think it's going to be great, and we've kind of drafted up summaries of the topics. I'll just read the first one. So consider that a few years ago, the Supreme Court decided that computer-implemented inventions are not eligible for patent protection unless they include something more in air quotes, than mere instructions to perform steps using a computer. So this term as well, with respect to copyright law, the Supreme Court is deciding whether copyright protection extends to a software interface. So the question that we're going to pose to the panel, of course, is should we just declare that software is free from the regimes of intellectual property law, free from copyright, free from patent? Would that be good? Would that be bad? And what other potential intellectual property rights should be granted to creators of software? And the unique challenges that software presents to the traditional intellectual property doctrine. So with that, let me just welcome up Shannon, and she'll introduce our panel. Thank you.
All right. Well, thank you, David, for the very nice introduction. I think we're going to have a really interesting panel today. And so let me start just by introducing our panelists. To my immediate right is Gerardo Diaz, and he goes by Con, so that's what you'll hear me call him. He is an associate professor of science and technology studies at the University of California, Davis. In the middle is Adam Mossoff, who's a professor of law at the Antonin Scalia Law School at George Mason University in Fairfax, Virginia. And then to my far right is Bob Sachs, who's the president of Robert R. Sachs, PC in San Francisco, California. So welcome. Thank you everybody for being here today. And as David mentioned, our topic is software and intellectual property. Should software be free? So let's begin with a definitional issue. What is software? So let's start with Bob.
Well, we all seem to think we know what software is, and we use it all the time. It's pervasive and ever-present. But I think there's actually a lot of misconceptions about it. Certainly it's at one level, the actual implementation, the code that runs in your phone, in your car, as executed by a computer. That's the core aspect of software. There is software as well at the source level, what people actually type into the computer, and then that gets compiled into object code. That's core software. Then there's this nebulous category of when we think about software patents, which I think, and I can say I'm a software patent attorney, I've been doing that for 30 years. But upon reflection, I can almost say that very few of what I have done, of what I've patented, is actually software. It's algorithmic. It's process-oriented. There's very little software per se. So there's a lot of confusion as to the content. When we think about software in that case, you see flowcharts and diagrams, that's more algorithmic design, and that's probably called computational or algorithmic patents. But core software certainly is object code, source code, and its variants, HTML, Java, all of that would be software. Everything else is design, so to speak. And there's a lot of confusion as to what gets protected in that spectrum. So that's one way of looking at software.
So Adam, what would you add to that?
Well, I was just going to add that for the, and build upon a point that Bob referenced, which is that we hear the phrase software patents used a lot. You see that term in newspaper articles, in academic journal articles. That is actually not an official formal category in the patent system. There is no category of software patents that are issued by the U.S. Patent and Trademark Office to inventors. This is a term that was created for use in the policy debates, and it's something to be somewhat skeptical of when you see references to, oh, the problem with software patents, or we should consider getting rid of software patents. Realize that that is not a term or a phrase that correlates with anything that patent lawyers and judges and examiners at the U.S. Patent and Trademark Office are actually engaging in and talking about. As Bob also indicated, software is in everything. So to the extent that you are receiving patents on components or processes or other aspects of a coffee machine or your refrigerator or your automobile, very oftentimes those will contain elements that involve software, that involve computer software programs. When I often talk about these issues too, I prefer to use the term computer program to emphasize that you're doing something in the world with this thing. It's not just the binary code or the abstract notion of some mathematical process, but you're doing something, whether it's a word processing function, whether it's an email function, whether it's a cybersecurity function, or a data protection or other type of data storage program. In fact, that's why the Federal Circuit in 1995 analogized software programs in a case called In Re Allipat to digital machines. They said, these are just the digital equivalents of the types of kind of analog machines that people have been innovating and creating through history, and that we've now shifted to a digital framing and a digital reproduction of these types of machines. And in the same sense that new machines were protectable in the 19th century, whether a typewriter, the components of or the full program of a word processor program today should be equally protectable. If it meets all the other requirements of the patent system. It's new and novel and non-obvious and things of that sort.
Con, what would you add?
Well, I would add that these 2 points of view that we're seeing right now are sort of the end point of a very, very broad historical problem, and it's that software patenting in the United States has become a legal minefield in large part because there's no conceptualization of software that can actually satisfy all the stakeholders involved. So when you think about software, in the 60s and 70s, when these debates started to emerge, the view that Bob was telling us about, sort of the difference between the core software and sort of the design, so to speak, of the software, that was just one of the many conceptions that lawyers and inventors were actually advancing. And what was happening was, at the time that software patenting started to become a possibility, software itself started to emerge as a distinct technological entity. And so that emergence of software, how people were conceptualizing it, was just intimately tied to just the dynamics of the potential industry itself. So for example, IBM used to be one of the most vocal opponents of software patenting in all its forms, in large part because of some antitrust concerns. And so they actually advanced this notion for many, many years that software is a text and it has absolutely no place within the patent system. And then the small startups at the time were trying to make sort of a place for themselves in the industry, so they were arguing for these mechanical notions of software. They were saying, this is another circuit and it's as patentable as a car. But then what happened was that when they went to court, and they asked computer scientists what software is. Well, computer scientists wanted their discipline to take off too. They wanted to be seen as different from all the engineers that were in the room. So they were saying software is algorithmic in nature. And so you ended up with these three poles of conceptualizations of software actually arriving at the courts. In the briefs, in the amicus briefs, and basically in every opportunity that the industry and the courts started to interact, these three poles started to blur what it is that they were talking about. So when Adam is saying there's no such category as a software patent, that has been true from the very beginning. There has simply not been a stable notion of software that has unified all these discussions.
And there's also a lot of historical Carm's work in the history of software patents is excellent. First of all, they're not new. Right? You hear a lot of misnomer that the Federal Circuit invented software patents in either in re Allopat or Take Your Choice. They go back to the 50s and before that. People have been patenting.
I would say even before that. A point that I always like to make is in O'Reilly v. Morse in 1854.
Absolutely.
Morse, we know him now today for Morse code, but he was actually also the inventor, fundamentally, of the first operational electromagnetic telegraph. But he also did invent Morse code. And claim 5 of his 1840 patent was on Morse code, which is affirmed in a single sentence in that case. Everyone knows that case for its invalidation of Claim 8, but actually people forget that Chief Justice Taney summarily affirms Claims 1 through 7. Oh, those are obviously valid. And Claim 5 is on Morse code. And what's Morse code? A binary system of transmitting information on an electromagnetic machine.
But it wasn't a programming language.
I know.
The point is, when you hear about the Federal Circuit inventing software patents in the 90s, that's false. It goes back many years before that. So that's a key thing. And part of it also is that today we are used to this notion of software being this separable component, right? I can download an app. I have my phone, I can install apps, I can uninstall apps, so on and so forth. That is a relatively modern, recent conception. Historically, from the very beginning, software was intimately, you didn't have apps, right? What you bought from Big Blue from IBM was a single system, and software was inseparable from that. You had no ability as a user to do it yourself. If you needed something done, you called up IBM and they would come and they'd send their engineers and program something for you. So this separability aspect was a key development, and it leads to the thinking now that we can own and separate out and have this distinct thing, the software itself, and there are rights that attend to that and uses and affordances of that. That's a development which, again, from depending on your what stakeholder you are, is either something you want to support or not support. But so there's lots of variants.
I want to make a plug for Adam's paper on O'Reilly v. Morse. It's one of my favorite papers ever. It's fantastic. But this separability, it is a ridiculously new thing. The when patenting started to intermingle with programming in sort of a modern sense, this all started to happen right after the Second World War. And there was a mathematician at Bell called Richard Hamming. And he had made this error-correcting code for a computer, literally loaded onto a computer with punched paper. And then he wanted to publish this program that he had written in the Bell Systems Technical Journal. And the lawyers told him, you're not going to publish anything until we have cleared this and gotten a patent. And so Richard was extremely confused by that. He thought, algorithms, I don't know what to do with that. But what they started to do was this patent drafting technique that up until the late 70s was called embodying software, which was essentially transforming a program into a series of statements about how a machine would operate in accordance with the program. And so these early patent protections were directed at machines, but essentially they were machine patents that were designed to cover all these programming aspects. And so when Bob's talking about the separability of software, well, this was in large part because of the dynamics on the industry itself, but that was sort of a commercial artifice more than a technical necessity. Sort of software and machinery have been inseparable since the very, very beginning of modern electronic computing.
And I also, this is sound like a mutual love fest, but plug Khan's book, which is awesome that Bob has already referenced. It's just a fantastic, in-depth historical survey of this whole historical development of software and the IP issues related to it. And like all good historians, he went to the primary sources, which is what matters most. But you mentioned this point about the kind of the evolution of this distinction between software and hardware as a commercial artifice. But yes, commercial artifice in the sense that all commercial developments are artifices of society, because this was a very important development, right? That Bob already highlighted, this kind of starting of the separation of software from hardware as separable products or separable innovations, which we now identify as the personal computer revolution that begins in the 1970s, right? This is really a key development for driving I think a lot of the sense of, well, what type of protections do we need to provide for innovators here who are creating value and are deploying that value in the marketplace now as products or services that are being purchased by consumers. And so software which is code, right? Originally they thought copyright protection because it's written, but then as you have the development of the software revolution through the PC revolution, right, and you get the ability to present the same functional value in a program as experienced by an end user, but it can be done with different code, and it can be produced through a darkroom process where you're not directly copying the code. Now the functional value to the consumer as a commercial product in the program, this is why I like to call them software programs, is no longer being secured effectively by copyright, which is why you actually start to see the more significant push for patent protection starting in the 1980s, because that's what patents protect. And that is the important distinction between patents and copyrights. And so I think it's a really fascinating historical story, because what you see is this symbiotic interplay between kind of commerce developing, technological changes, and the law evolving in response to that, as it should.
Excellent. Okay. Very good. Okay, so now we kind of have an idea of what software is, right? Now the next thing, what do we mean by free? And Professor Taylor alluded to what we mean by free, but there's a lot of thoughts around that. So let's start with Adam this time.
Oh, free to be me and you. There is a lot of similar to software. There's a lot of confusion about what we mean by free and open source and the accessibility of software products. So. Of course, there's open source as a business model, which doesn't necessarily rely on patents. Does rely upon copyrights in order for people to say, I, as the creator, am giving you permission to do whatever you want with it. It also relies significantly on other types of intellectual property protections for the companies that develop it. So, Red Hat, which is a company which has a business model developed around open source, which is now merging with IBM. So it'll be interesting to see what happens there. They love to go around and say, oh, there should be no IP protections. There should be no IP protections for software and things of that sort. To which, to which my response is, okay, and so you go ahead and use Red Hat's technology without acknowledging them, or use their name or symbol without getting permission from them, and you'll see how much they like certain types of IP protections, like trademark, right? There's open source as a business model. In fact, IBM is officially on record as saying that, as a company that uses open source, that they think that patents are really fundamentally important to driving open source as a business model because of its forced disclosure requirement. They filed a legal brief about 10 years ago as an amicus in a case where they made this point that we rely upon the patent system, and we think the patent system is fundamental for having open source technologies and an open source business model because of the forced disclosure that the patents require. You can't keep these things as trade secrets. And they caught a lot of heat for that from the open source, for lack of a better term, kind of the open, not the business model side of it, but the open source kind of movement side of it, the philosophy, which thinks everything should be free, no one should own any of this, which is really funny. IBM is saying, "Look, we do open source," but Ars Technica and other websites were very upset with them for saying this, because there's also this. People think of open source, they think of the philosophy of open source. So people who go around saying there should be no ownership of anything, this kind of this very idealistic notion of everything, all of this should be free. Computer programmers don't want to do this. Of course, computer programmers are paid salaries by companies that have to deploy these products in the marketplace and engage in contracts and commercial exchanges and creating the value chain to get these products and services to consumers. So but it's very important to distinguish between, I think, the business model of open source and the kind of the philosophy or ideology of open source, which often get conflated, I think, oftentimes in not just in the policy discussions, but even in legal discussions as well.
Yeah.
Right. So, free, like, I guess from the user's philosophically, from the user's point of view, I guess when we were preparing for this, we looked up what Wikipedia said about free software, and it's, of course, that's the source for everything. So it very much focused on the user side of things, and its definition said it allows the user to run the software for any purpose, as well as to study, change, and distribute the software. So it's just philosophically really interesting, and from an IP attorney perspective, I'm like, that just doesn't feel right to me. Somebody's innovated something, and now everybody can use it and do whatever they want with it. So,
well, from this more philosophical angle, I think the meaning of the word free, there's two direct connections to it. The first one is free as in free of cost. You don't have to pay. But the other one, especially for the free software movement, is this notion of free as in freedom. So you will have the freedom to do as you please. So then when you're thinking about free and open source software, there's this collection of questions. Is this free as in freedom to use it as you wish? Is it free as in there will be no cost associated with it? And then when we're thinking about open source, is the source code itself openly available through some conditions and license agreements, depending on the business model. But all these things, they're not necessarily mutually exclusive, and I think that this is why this question of should it be free is also hard, because that meaning of free will depend on the context where you're asking the question. And one of my favorite historical anecdotes about this is that when sort of conceptions of open source software started to develop, sort of the contemporary ones, the makers of this software realized that they wanted to be able to distribute their software. They didn't want to have any IP protections for it, but at the same time they realized that free as in cost free made no sense. So then they started to sell software by the pound. This was a time when software was punched paper. So they would punch the holes, and then they would weigh the paper, and then they would compute how much you would pay for your software based on this. But the moral of the story here is that even in these conceptualizations of open sourceness and freeness and freedom, cost recuperation was a primary concern. And I think this is why we keep returning to these business models. The idea was that you would recover the costs of developing the software and of the labor involved in punching the holes by charging for it by weight. So this freedom didn't mean cost-free, because it's never cost-free.
Yeah, and that's, I think it's acknowledged that it's not free and zero cost, or you don't pay for it. The core concepts are certainly freedom to study it. You can look at the code, you can understand the code, you can freedom to modify, make essentially what we would call derivative works on the copyright side, freedom to distribute it, again. Those are the kind of the core, and freedom to use it in any fashion. Now, the first is like, as you said, wow, as an IP attorney, that doesn't make any sense to me. Makes actually a lot of sense to me. If I think of software as a manipulable product or thing, if I buy a toaster, I can do whatever I want with the toaster. I can take it apart, I can modify it, I can improve it, and I can vend it again. Right? And I can make copies of that toaster. I mean, I could go in my garage and I can machine parts. I can do whatever I want with that toaster. Well, as an innovator, I'm innovating. If I'm taking a toaster and I make it better, I'm innovating. If I take a piece of software, I paid you for it. I bought my $50 copy or my $100 copy or whatever it costs. I'm going to go manipulate it and revise it like it's a toaster. So it seems to me if I have the right to do that with my toaster, if I have the freedom to do that with a toaster, in one conceptualization, I said, well, then software is just like a toaster, and I should be able to do that as well.
Yeah, I want to push back as well a little bit on this, on the sense of, historians and economists who've kind of looked at the history of the development of the U.S. patent system. I mean, Khan is one of these people who does a lot of this great work. The United States was unique in protecting intellectual property as property. We were actually one of the first countries that kind of began to do this and to say patents and copyrights in the 19th century, even trade secrets, we still diverge from England and other countries in treating these as property rights as opposed to an amalgam of, of personal relationship rights and contract rights and other and torts. That the key to protecting this property, why protect this property, is that property provides a domain of exclusive control for you to have the freedom of choice as to how do you want this asset to be deployed and used in the world. Mm-hmm. It's a platform for private ordering, for making decisions about how you wish your things to be used. And that can mean I want to lock it down. I want to be the only person to provide this and to sell this product, because I'm awesome. So,
What is your awesomeness?
Well, no, hold on. I mean, that's one choice, right? That's one choice. And then you can go in the market and see if my awesomeness will work or not, right? But other choices are, well, actually, I want to license this. I want to embrace our division of labor and specialization, which is what Adam Smith said in 1776 in The Wealth of Nations is the key to flourishing innovation economies, right? With his example of the pin, that different people contribute to making pins. This is why pins are so cheap, and so this is what licensing prohibits. I can invent if I'm an inventor or I'm a creator on the artistic side, and then I can license my work. I can trade it to the manufacturers, to the business persons, and they can develop it. In fact, you can think of the movie studios are very much like venture capital investors who just organize in venture capital investments in movies. There was a great presentation several years ago at a conference by Troy Dow who walked through kind of how Disney very much is like a venture capitalist who's, because you have the startup person come to them, the producer, the director, the person with the idea for the movie, and then they invest in this person, and then they create a little startup with a whole company to create this movie. in the patent space. This is why, Samuel Morse, as I mentioned earlier, but even Charles Goodyear, when he invented vulcanized rubber, and Elias Howe, the inventor of the lock stitch on the sewing machine, and even Thomas Edison, they engaged in a lot of licensing of their technology to other people. Yeah. But you can also just say, I want to get a copyright on this because I want it to be free and open to everyone. In fact, so a lot of people may not know this, but the discoverers of the AIDS virus in 1984 got a patent on it, on their discovery, on their isolation of the AIDS virus. And they were asked about this. Why did you get a patent on this? Because everyone assumed they were going to lock it down. And they said, we got a patent on it because we want to ensure that it's open for access for research for everyone in the world. And the way we can ensure that is we get a patent on it. It's ours now, and we can then declare to the world, anyone can use our property. And that's how it was then ensured that you had open access for all research on the AIDS virus after that.
Okay, except there's one fundamental issue, which is where on the scale do you put the thumb? Mm-hmm. In a cosine, it's kind of a cosine. Where do you allocate the base right? Right? What you're saying is the basic framework should be the property framework, right? That the bundle of rights go to you, Mr. Awesome. Right? And what I'm saying, I'm suggesting, and again, I've been called many things, including an IP maximalist. What happens if you shifted the other way? Yeah. You want to go out and you want to license it? Fine. Yeah. But the fundamental assumption, the base assumption, is that it's not protectable in any domain. And you're only if you want to license it, if you want to control it, fine. Yeah. Go offer it in the marketplace for $10,000 or whatever you want to sell your toaster for. And if people want to buy it with all of your restrictions, they'll buy it if they don't want to buy all the restrictions. But the rest of us, once it's in the marketplace, once it's out there, we can do whatever we want with it. Mm-hmm. Why should the default be towards giving the innovator, the initial creator, all of the powerful rights? Look at Disney, right? The slightest song, the slightest image, 95 years of protection. Mm-hmm. What is the benefit to society of that? Maybe the benefit really is you can do whatever you want with it in terms of licensing it or using contract rights, but the default is that outside of that, it's free, it's unrestricted. I want to use the word, it's unrestricted use.
Yeah, that's a really great question, and that's not a question that's unique to IP. I mean, you're the exact same debates in the property context. Why should we allocate the fee simple to the person who just happened by accident to arrive at a piece of barren, unclaimed parcel of land, fallow land? Why should we let that person then, after that point, get to decide how that piece of land now?
Because they built a fence around it.
Well, and then you can always say, well, I was the person who discovered it or invented it. I was the person in historical classic terms that people know me for, engaged in productive labor to create this new product or service. And so just like you're right that the discovery doctrine is not just I walked across something, but that I actually started to till the soil and build a house on it and do something with it. At least discovery doctrine as it should have been implemented, as theoretically framed. That IP doctrines, and this is historically the case, that they were, the United States went with the first to invent system. That was a break from England. England did not have a first to invent system. England had a first to filing system, which is what we have now after 2011 with the American Invents Act. And we went with the first to invent system, in part because they said they analogize this, that inventive labor, inventive work is tantamount to the same type of physical work or physical labor that justifies the initial creation of a property interest
and that's alchemy.
Other assets.
That's alchemy. Analogizing is alchemy. Yes. Right?
Well, that's the law. That's how the law functions. Through those types of connections. But it's legal alchemy.
And I'm saying the connection is a false one. Right?
Well, you're analogizing yourself. You've been talking about software as toasters, right? So
no, because it is a toaster. My point
by the way, Cylons would be very upset at your pejorative use of toaster.
So you're thinking of software as toaster, and so again, we're going back to that murky question: what is the software that you're trying to protect? But as soon as you start talking about your using of the toaster as an analogy for software, you're already thinking of sort of a mechanical conception for it.
No, I'm thinking of it. It's just as the toaster is not copyrighted.
Okay.
and I can do whatever I want with the toaster. I mean, we have first sale, I'm kind of ignoring the first sale doctrine for the purpose of this discussion.
Yeah.
This intellectual property, what I'm saying, if you want to use contract law to protect it, that's fine. But the base, kind of the default, right, that as soon as you embed it in a tangible medium of expression, now all of these vast attendant rights immediately attach. That's what I'm calling into question. And that is in my view, is.
Well, you can't have contract is an exchange of rights predicated on my ability to have exclusive control in determining what rights I'm exchanging. And so in a sense, contract is parasitic on property. You can't have, contractual exchanges unless you first determined I have the ability to say, you can't use this unless I give you permission to it. So we need to have a discussion and enter into an agreement on the terms on which you can use or access my things. In other words, you have to have property. Now, that property can be legally recognized, or it can be enforced as a social norm or through other types of mechanisms. But the concept of contract is predicated upon first having a concept of property, having an exclusive control in something. Because otherwise, then, why would someone contract with you? Because if you can't say no to them and keep them off, they'll just take it.
Because prior to distribution, you have that exclusive control. So you don't.
Yeah.
I'm suggesting that you don't need this additional. This base framework, right? In other words, until you hand it over to me, you are in conclusive control. And I will agree you will only hand it over to me based on whatever the terms that we negotiate. Yeah. And once that's done, so we don't need the copyright law. We'll just contract everything. Now, there's a vast overhead. Yeah. I think that's where we're going, is that there's a vast overhead, but it's the allocation of rights. It's that initial allocation of what can and can't be, what falls within the bundle and right, and what falls outside it. And the suggestion is that copyright and possibly patents are just simply too powerful. They're too powerful.
Right.
They allocate too much to the innovators and less to the users or developers or other innovators.
Yeah. That's a legitimate policy argument in the debate, right?
And that's a lot of free and open source software are basically along these lines. And it's this question of, whose rights come first? Do the rights of the innovator come first, or do the rights of the user come first? For free and open source software, one of the overarching conceptions has been the user has the right to use, this is not a legal right, the sort of conception of a user's right, the right to use the computer as a liberatory tool. And the corporate control or the private control that patents and copyrights offer sort of stand in the way of this user's right to engage freely with a machine. The way that these early conceptualizations of freedom thought about software was onions. They actually had pictures of onions in their talk. So they would project a picture of an onion and say, look, at the very, very core of the onion is the physical, tangible machine. The layers of the onions are the very different layers of software that you need to, in order to interact with the machine itself. The user's rights should sort of allow them to crawl all the way to the machine itself. So where the rights kick in for free and open source software is not with the creator. It's with sort of this community prerogative of freedom to engage with the computer.
And what I'm saying is that makes actually a lot of sense to me in the same, and I'm not doing it by analogy when I say that software is a toaster. I am looking at software as the mechanical aspect that in my view that it really is. And so in the same way that we move from toasters to automobiles, right? If you go back to the height of the American automobile in California, right? You bought a hot rod and you got out there and you adjusted carburetors and you would change the muffler. I mean, I did a lot of stuff like that. If it was the case that you bought a car and when you bought the car there was all of these rules and requirements, you can't modify the car in any way. And I would be like, wait a second, I can't go modifying my car. I can't change the transmission. I can't do this. That would be really restrictive. Right? So the user community would go, wait, we don't want these restrictions. Why should all of these restrictions apply to a car? If they don't apply to cars and toasters and whatnot, why do they apply to this expression of mechanical functionality?
Right, but you're taking that hypo. The hypo you've raised is taken in context, right? There's a reason why they impose those restrictions. I mean, it's the same reason that people get land and other types of assets with all sorts of restrictions, right? I teach first-year property, and you spend like one day on the fee simple, right, and the rest of the, and then a month on all of the highly restricted forms of property that do exist, where people don't get the full fee simple. And why does this happen? Well, there's two justifications or underlying justifications for this, which is, by the way, was translated into IP on the basis of these underlying common law cases in property. This is kind of my historical scholarship.
And that's the whole problem.
But, well, no, wait a minute. And well, it's not a problem because I'm getting to the explanation of why it's not a problem. So is that there's the moral argument. Well, if you've, that I have already highlighted, which is if you've created something, if you've done the original productive labor in producing something of value and use, then you should have that gives you the right then to determine, how this is going to be used in your life, and what and how it should be used in a flourishing life for yourself and in society generally through free exchanges with other people. Wait a minute. I said there's two, so let me finish. So, and then that comports with and ties in with the economic justification. So there's also then an economic justification, and these restrictions that you keep invoking. Oh, I'm heavily restricted. Well, guess what? What is the difference between in the marketplace between buying a fee simple determinable or a life estate and buying a fee simple? Is that the fee simple determinable or the life estate are a lot cheaper, right? Is that when you sell in the marketplace or transfer in any way, shape, or form a lesser right than what you have, the person who's buying it from you pays less. And this is what allows for what economists call price discrimination, because then you maximize the ability to deploy assets in the marketplace. This is Adam Smith's great insight about division of labor and specialization and the splitting up of property rights, the freedom to split up property rights that allows people then to engage in these private ordering decisions on the basis of their recognition of the value of the resource, so that people then who can't necessarily afford the full fee simple, right? Or if you've created the invention and you've got to, you get the one opportunity to sell it once, right? Great. So for all of those great pharmaceutical innovations, the coronavirus vaccine will eventually come out, great. The first pill will cost $2.6 billion because that's how much it costs on average in R&D and going through the FDA approval process before a molecule that's originally identified in the R&D process is deployed as the therapeutic treatment in the marketplace, right? Who can afford $2.6 billion? Wait. But
That's not software.
right?
You went from land
Yes.
to drugs,
Yes.
neither of which have anything to do with software. Your whole argument, this fee simple, you're talking land, right? If I recall correctly, you're talking land. You're talking
it's
physical
rights.
property.
It's rights and assets. Yes.
Rights and assets, but it's all grounded in land.
No. Nope. That's not true. Land is not. This is again another confusion even in property law. Land is not the foundation for understanding property. Property rights don't even start in land. They start in actually personal goods, chattels. And property is rights in water, rights in air. It's any rights that establish exclusive control over an asset that you've identified and created into a value.
It's this notion of physical assets.
No, not physical. Air. How's air physical? How's water physical?
I'll tell you. I'll show you quite quickly how water is physical.
Yes.
Don't go there. And this notion of, but see, air itself is that was attended.
But you as an attorney know that software has a lot of similar dynamics to the same types of R&D investments that you see in the biopharmaceutical space. I mean, one back of the envelope estimate was that Windows Vista cost Microsoft $10 billion in R&D expenditures before they sold a single product, right? And how many copies of Windows Vista did they sell? Not many, right? And that was $10 billion in R&D expenditures, because you know that when you develop enterprise software systems and operating systems and email systems, and you need those types of exclusive control rights in order to recoup your investments and deploy in the marketplace in order to continue more. But if you're making Flappy Bird, you don't need the Flappy Bird app, you don't need patents or copyrights, and they don't ask for patents or copyrights.
And if I come up with
Well, there can be life-saving softwares. There's in the future, we're going to have things that are going to be akin to pharmaceuticals.
Well, no, they already are. That's what I'm trying to say.
I can right now, in about 30 or 40 lines of code,
Yeah.
I can develop a full-blown AI application for facial recognition. It takes me about 30 or 40 lines of code to do it, okay? Now, the notion with, wow, so now that I have this huge bundle of rights, I can write a song. I mean, let's forget software, right? Let's just take music, right? Any of us can hum a tune, and the moment you do that and you record that, you now have this huge bundle of rights. What I am saying is, in the same way that, yes, there's this notion of exclusive control and investment in properties and all of these things. Yeah. That's all based on this notion of this hierarchy. I'm going to get really philosophical here. This notion of exclusive control is the whole issue, right? That there's somehow this supervenient power that it's the entity, it's the person who controls this physical thing. Starts with, I mean, you talk about air. It starts with the land. It starts with the water. But it would start about physical control of those assets. And then it gets abstracted out to chattels and other kinds.
You see, this is an example of the importance of framing. What you call control, I call choice. Freedom of choice.
Right.
And the ability to engage in freedom of choice with other people who are exercising that same freedom of choice.
Exactly, okay.
And this shockingly correlates with, strongly correlates with growing innovation economies and flourishing societies, where you have the protection of intellectual property in the same sense, and again, it's just again, it's not mandatory. It's because it's predicated upon what you do. If you write a program in a few lines, a few times, you're not seeking patent protection. The Angry Birds developers, right? They didn't get a patent on Angry Birds, and they went around saying, "Oh, we don't need IP protection, and we're totally opposed to IP protection," because they were conflating IP with patents. But then all of a sudden, when all of these knockoff Angry Bird products started appearing in the marketplace, coming from China, then they started suing people left and right for trademark infringement, because that was the way that they captured their value that they had created. It's that what this legal system provides is a menu of options for people to have the freedom of choice to engage in society on the terms that they wish, with other people who are making those same choices. And so this is why the open source system developed as a business model. Yeah. It was made possible by the very system of this strong, huge collection of rights, control that you're saying shouldn't exist or should have prevented this from happening in the first place.
No, I didn't say it shouldn't exist.
Moreover, I mean,
I'm questioning where the thumb is placed on the scale.
You would have to explain, how is it possible that while we've had the offering of all of these huge controls and excessive restrictions, I'm quoting your language, restriction, control, clamping down. While we've had all of that, we have had some of the most explosive growth in this country.
Absolutely.
Technologically and creatively. While you've had firm protection of reliable and effective property rights, and you can probably confirm this as well as a historian, but it's Zarina Khan and Steve Haber and other economists and historians have looked at both, not just the 19th century like I have, but all the way up to the 20th century, right, correlate very strongly in the same way that you have correlation of property rights with growing economies generally, all property rights, of intellectual property protection with growing innovation economies and flourishing societies and growing creative industries as well.
Well, that's exactly why the software patents themselves started to become popular in the US, because without these patent protections, all these smaller developers felt that they just couldn't compete against IBM and all the other hardware manufacturers. So actually, the patents themselves are, in large part, the reason why the software industry could take off. Because even if they didn't file suits for infringement, they considered the ability to secure these patents as the necessary precondition to carve out a market for themselves in the industry. Without that, especially sort of in the 70s and 80s, without that, it would have been unbelievably easy for one of the larger manufacturers to come in and just take over. And so where we should put the thumb, I think where this conversation is going in large part is that we should put the thumb wherever it works for the innovator to put the thumb. Because for a large company like IBM, right now, one of the big choices that they're making is that they would like to secure whatever protections they can, but then have the choice to offer it free and open source. For some of the smaller developers that I've talked to, well, depending on what they want, they just don't want any patent protections, or sometimes they do for the same reason as the early ones. So it's
Okay. Well, so again, I've been writing and prosecuting patents for almost 30 years, right? And I've written them on everything in the software domain. The notion, and so I think I can say, I'm still skeptical about the real value to enterprises, particularly small companies, of having a software. Yes, it's a prerequisite. It's the ability, it's this notion that one day, maybe, we could sue somebody who infringes, but that's such a small, the actual numbers how play out, how many times that actually gets done. It's major, it's the big companies. Yes, there's the incident where small companies, Stack versus Microsoft, or lots of time. Sometimes it happens, but statistically speaking, it's relatively small. Let me just finish. So, and where does the money actually flow? The money flows to the big players. I represented well-known companies. IBM would show up. We have 100 patents, and we would look at these and this has nothing to do with our business. This has nothing to do with our technology, and yet demand big piles of money. And so you could say, well, that access to IBM's patents or any large company's patents, that didn't aid my client's ability to innovate. It was a tax. It was directly taking from their engineering budget and going across the aisle.
Yeah, but the question of where, statistically speaking, the money falls is not the question of where the innovation is happening. So, for example, flowcharting programs. Statistically speaking, they were one of the smallest early collection of programs that you could have sold. But they were, the developers of these programs were extremely interested in getting these patents, even if they weren't getting the bulk of the money. Airline reservation systems, financial processing systems.
Why?
Statistically speaking, what?
Why? What is the value of the patent unless...
There's a really great work by Jonathan Barnett on this where he has shown that weak IP systems actually create barriers of entry for startups and individuals and actually aid current market incumbents. Because if you're a current market incumbent like IBM, you don't need patents for innovation. You use them to stifle, to threaten.
Exactly.
But because you have, you're IBM, everyone already knows you, you have massive goodwill, you already have established market infrastructure in your value chain, and massive money in the bank, at least you used to, to be able to deploy products and the services. So who actually relies on IP protection the most? It's actually startups and individuals and new innovators. We see this on Shark Tank every week, right? When the person comes in, they come in and when the VC guys and women hear the presentations and then they like something, the very first question they say is, well, do you have a patent on this? And if the person says no, they're like, well, you're an idiot. You just went on TV and gave away your idea to the whole world. Why were we going to invest in you?
But
right?
that all begs the question.
So, it's not begging the question.
No, it does beg the question
because
just because VCs say, if they ask that question, they are assuming a whole context. That's not evidence of anything.
No,
that's not evidence of anything.
It's the relying, because the property right in the patent is the basis for them to make the investment in the collateral, right? I will give you an exchange just like you in a mortgage. Say here's my house in exchange for the
patent is irrelevant. I have told my clients for years, this patent is not it. You will either win or lose in the marketplace well before this patent issues, and even once you're not going to win. You're not going to win the world. You're not going to win the game because you have this patent.
Well, I
you
can't
will win
speak to
on
the advice that you were giving to your clients, but I can speak to.
It had nothing to do with me.
I can speak to the studies and what they show is that the patents are essential for. I mean, and the case studies show this out, and the survey studies show this out, and there's growing now more general statistical evidence to show this as well. Is that patents are essential for individuals and startups precisely to protect themselves against market incumbency because they don't have established.
That's all great theory.
Yes.
It's
not
all great, and it's good statistical data. But
it's
what
not
I am
theory. I'm invoking. I'll email you all the studies.
I'm sure there's lots of studies. But what I'm saying is that when you actually are at the point of this company, and they're about to spend some money. They have these patents. Whether they're going to be successful as a company is often completely irrelevant to those patents. They will either succeed or not based on their ability to deliver product, their marketing, their engineering staff. Are they a functional company? Hundreds of other factors dominate whether they will win or lose in the marketplace, and whether they have a couple of patents that if they fail, the investors can then go.
You're not responding to the point that I made.
No, I am responding to the point you made.
Because you just converted my argument into a reductionist claim that it's all the patent. And I didn't say it was all the patent. I was identifying one aspect of which patents serve a key role.
What was the key role?
The key role is to obtain venture capital funding, which then they can deploy to hire employees, do more innovative work. And this is in fact, this has now been statistically proven in a very important study by, his name is Hegda, is a professor at NYU, where he got access to about tens of thousands of patents at a patent database at the US Patent and Trademark Office, and found that having a patent for a startup more than doubles its chances of receiving VC funding.
Again,
Wait a minute. Then he took that further out because that's a reductionist claim. And then he showed that then he was able to then show not a correlation, but causation, that those companies that were able to get the VC funding, because they got VC funding, were able to invest in hire more employees, and continue reinvest in ongoing R&D and other types of important expenditures, and develop the value chain necessary to get through the valley of death, to no longer be a startup and to become an SME, that they actually have higher chances of success in the marketplace.
Okay, wait. There's a big problem here.
Guys,
We're not talking about
just a few
software.
more minutes. So
We're
I wanted to shift gears a minute because we've been kind of focusing on the patent side.
Yeah.
But the Supreme Court is going to be dealing with software on the copyright side.
Yeah, small case.
Yes. So I want to hear some quick thoughts on Google and Oracle's big fight over copyright.
All right. Bob?
You seem to be very...
I'm with Google on this one, I think, which is odd, but nonetheless, yeah, they copied the 7,000 or 11,000 lines of header code, but the purpose that code is primarily for interoperability. So anyone could write and could run Java applications on top of Android without having to use Sun's to implement the actual Java virtual machine. So it was purely for functional purposes. And in this position, then the copyright that is very, very thin protection. And Google would have that ability to create that structure and implement it that way. So I would say that going in that direction, I would kind of go with what the district court found, and was then reversed by the Federal Circuit.
I'm a little torn in the sense that whether code is just for functional purposes. When I speak to computer scientists developing these kinds of things, the language that they use is so full of creativity. This is beautiful. This is clean. This is elegant. Mm-hmm. There's an emotiveness that these developers sometimes associate with sort of the technical success for it. And so whenever I think about how creative could this entirely functional piece of code be, I keep returning to this language that they use so often.
Yeah. And
that's completely misleading. It has nothing to do with it. No, it is. It has nothing to do with anything.
How people conceive the thing that they're creating is not a misleading thing.
well, let me.
That there may be beauty and elegance in that creativity is a separable aspect from the thing itself that is created.
Well, then what
that's
I
a
was
beautiful thing. I can go, wow, that's a really elegant.
No. So the reason I'm torn is that I don't know how these lines of code were conceived by the people making.
Well,
so I'm not making a legal argument. I'm making a philosophical
the creativity
argument.
requirement in copyright
Yeah.
is fairly minimal.
Yeah.
I know you're all going to be shocked by this, but I disagree with Bob. We've known each other for a very long time, so we have these fun discussions. The whole argument about functionality and that this is about interfaces was a completely ex post litigation developed argument by Google through the lawsuit. I mean, they have the emails, the direct emails that came out through discovery that were introduced at trial, the emails from internal at Google. We could create this code, but it'll cost us a lot of money, and we lose the value of the user base that's already been established at that time by Sun Microsystems, later purchased by Oracle. And so we need to either take a license, and Sun Microsystems had 3 licenses. One of them was an open source type license. They freely licensed. They were like, take, please. We want you to use our code. We should take a license. And the response was, no, we'll just copy the 11,000 lines of code. And why? Because it's cheaper and easier for us. This is a business practice that's now identified by the policy wonks in DC as efficient infringement, where a business makes a commercial decision to just take someone else's intellectual property work. And in this sense, and Congress made the decision in 1980, code is copyrightable. And if you directly copy code, you are directly copywriting, or you're directly taking copyrighted work. Now, Google is trying to argue that, well, there's code, and then there's code. And now they're trying to argue that, well, so the Supreme Court should now make differentiations between different types of code. And that's not in the 1980 statute. The statute says, look, you write 11,000 lines of code, and somebody copies that verbatim, that is a copyright
It's not a program. The header files are not programs. They don't execute. They are the index. They are a set of naming conventions that direct the compiler to where to find the code.
That's a patent issue.
No, it's not a patent. It's a copyright issue because it's not a computer. It's not a computer program.
It's solely lines of code.
No.
It's code.
It's code, but it's not a program.
So you're now asking. So you're asking the court now to differentiate between, well, when Congress said code is copyrightable. Well, now the court should construe.
They said computer programs are copyrightable.
No, I think that the language says code in the statute.
But even so,
Christella, you're our copyright expert.
The point is that this is the core thing is a functionality. Okay, you are not the copyright does not extend to functionality.
Right.
Okay, and that code is purely functional.
All code has functional.
Right. Its level expression is minimal. It's extraordinarily minimal. I mean, there are a lot. Print. How else at least in English, the concept of you have a merger issue. Now I know that the Federal Circuit said, well, the court kind of confused. Where the merger doctrine is and what all of these things.
I think this is very basic. Is that you had 11,000 lines of code. That code had value because it's a functional value. Guess what? A novel is thousands of lines of words, and it has value because people find functional value in reading that book. And yes, the functional value of that 11,000 lines of code was exactly why Google copied it directly. This is classic copyright.
The question is not whether you're looking backwards. That they copied it is somehow evidence that it was protectable. And I am saying that no, that's begging the question. The fundamental question is this the kind of thing we want to protect in the first place?
No, I say the cut that they copied it is the evidence of an infringement. The code is directly copyrightable per the statute. The code is copyrightable. And then it says the functional aspects of it.
If it's such a clean question, if it's such a clean question, why did the district court spend dozens of pages of analyzing this? It was so
came up with a really good, sophisticated argument, just like it did in Google Books, about why this wasn't copyright infringement, and they succeeded in convincing the district court in Google Books for the same that this is not copyright infringement, this is fair use. Just because this is part of efficient infringement is that you're a company with billions of dollars in the bank, and you can come up with you can spend a lot of time coming up with really good, sophisticated arguments after the fact when you've told people to get lost when you won't license their product or service.
I hate to do this because I'm really, this is a great debate. But we are out of time. So would you welcome me and join me in thanking everybody for your.
All right, I'm tempted to ask for a vote, like who won the debate, but I'm not going to do that. I'm just going to say thank you. We'll take a 15-minute break. Feel free to go out and get a drink, get some food. You can bring it back in.
Don't wait just yet.
And so we'll start back up in 15 minutes.